A really important question is whether or not you can terminate a trust early. So let's get into it. All right, so can you terminate a trust early? It's a great question, and the short answer is maybe. And before I give you the details on when you possibly can do it, as a quick reminder, a revocable trust can be revoked, amended, terminated. There's really no limit to what you can do with that trust. So this question isn't really applicable to the revocable trust because yes, you can terminate a revocable trust at any time. So the question is really applicable to an irrevocable trust. And there's three things that come to mind, or three different topics that come to mind when discussing this question. So the first one is, yes, you can terminate a trust early if there are provisions in the trust that state that you can do so. So even though it's irrevocable, that language may already exist in the trust. And a perfect example of this is that it gives discretion. The language will give discretion to the trustee to terminate the trust early if it's no longer economically reasonable or feasible to continue with the trust. And so when you see this, it's that the expenses associated with running the trust or administering the trust are greater than the income that's being generated, and it's eating into the principal to the point where it no longer makes sense to carry on with this trust. So the trustee is going to have the discretion, again, if that language is in the trust. So second example, and this is really going to be dictated by state law. So the second and third one are really dictated by state law, but the second one could be kind of similar situation. But let's say that there is not language in the trust that gives the trustee discretion to terminate the trust early, but it's still economically no longer making sense to continue with this trust. The trustee or the beneficiaries could petition the court for a judicial modification or termination. They get the permission of the court, of the judge, to terminate the trust and make a final distribution of these assets in the trust to the beneficiaries. So that's the second way. Third way, again, that's going to be dictated by state law, and some states allow for what's called the decanting of assets. So if you have a first trust, and let's say it's no longer working for you for a multitude of different reasons, change in family circumstance, financial circumstance, it could be anything, change in laws. But if you can decant that first trust, that means you're going to assign the assets to a second trust. It could be a brand new trust. It could be a trust that's already been in existence, but you're essentially impoverishing that first trust. You're depleting of its assets and moving it over to a second trust. And so because that trust no longer is funded or no longer has assets in it, it's really obsolete and doesn't really serve a purpose anymore. So it's not necessarily terminating the trust early in the sense that we talked about with the first two examples. But if that trust no longer has assets in it, it's no longer relevant and therefore isn't going to provide any benefit to the beneficiaries. That second trust would, and so you've thus rendered the first trust obsolete, doesn't really provide any benefit or serve any point. So that's a way that it would be terminated as well. So first example is that the trust says that you actually can terminate it early. Second one is seeking a judicial modification, the approval of the court to be able to do that. And then lastly, it is decanting.